And I'd like to point the committee to the recent case that was referenced here earlier from the Commonwealth Court, the Bagwell decision relating to Penn State, and just give you one little piece of history related to it, because I do believe it sends a signal as to what the court's thinking here. As you know, when that case came to the Office of Open Records the first time related to the Secretary of Education, the Office of Open Records denied the request and said that we did not have jurisdiction because it didn't fall within Chapter 15, and we passed, if you will. The Commonwealth Court sent that back and said no. You know, in this case, because of the statutory relationship between the Secretary of Education and his appointment to the Board of Trustees, that we did in fact have jurisdiction, and that case is now before us, and we're looking at the underlying merits. And I think it's the reason I raise it is I don't think it's quite as simple as to say that Chapter 15, you know, just limits what we have here, because I think the court is sending us a very strong signal about whether and to what extent Penn State, Temple, Lincoln, and Pitt will be covered under this. I also, in relation to the state-relateds, want to point out a couple of things that you heard, I think, from Senator Dinniman. Again, this is informative, more is to provide the committee with information than as to advocate a particular position. But there are only 3 states in the United States in which their similarly situated universities are not covered, and that's Alaska, Delaware, and Pennsylvania. And when you take a look at some of the issues that have been related in those other states, while the components of those universities may be different in some measure, there's also a lot of striking similarity. I'd like to point out to the committee that some of the concerns that were raised by research would already be precluded under the current state's right-to-know law. And I'm only focusing in this moment on Penn State because of the Sandusky scenario. When that situation occurred, it was the #1 issue that brought to the Office of Open Records the highest volume of requests and appeals related to that. Of course, because Chapter 15 is limited in what it's required to be provided, none of that information became available under this right-to-know law. And I offer that to you as an example of some of the differences about the state system, of course, and related to the state-relateds. You know, one thing I think that as you consider whether to cover the state-relateds, I think that as you look around the country, there's no university that's not without, there's no institution, Office of Open Records included probably, that's not without those, you know, sort of squishy moments of embarrassment if a public record is released. But as you guys, as the Senate and the House consider, you know, whether to cover those state-relateds given the amount of money that they give, these are just some things to be considering. The gentleman from Temple mentioned the privacy concerns. Those are already addressed. You guys did a great job of addressing those already in the right-to-know law. So for the concerns that were raised, at least before you today, 3/4 of them have been addressed already in the current right-to-know law. And obviously, if you had more specific questions about that, we would talk about that as well. Keep also in mind with the person that suggested the cost issue, the cost of not having a Freedom of Information Act or a right-to-know law access, I would assert, is much greater than the cost that is associated. And there's definite costs, and we've talked about those before, commercial fees and things like that. I can tell you that there's a direct correlation between corruption and poor right-to-know laws, and I would encourage you to keep that in mind. More information than not will be able to be withheld even if you do cover these state-related institutions by the mere fact of the fact that we have 30 exceptions in this law. This by no means is the most aggressive in the United States or even federally in that regard. And so I do think that it would be a tremendous effort on the state-related parts to, you know, to come under this and to even just sit down and figure out how to come under it. But the reality is, if anyone's operating under the misconception that you're going to see, you know, thousands and thousands and thousands of records pour out, I don't think that's the case. And also, I would like to say this. If somebody is looking to fix 444 because they think it would prevent a Jerry Sandusky scandal, it wouldn't. You could have the strongest right-to-know law in the United States of America, and those horrific crimes were still going to happen. The difference is that you might have found out a little earlier. in this regard. And as the deputy director has often pointed out, something that I've missed regularly, we got right-to-know requests related to Penn State and the Sandusky scenario. We didn't know that at the time, but in retrospect, when you look at these requests from the newspapers, they knew something was going on, but they immediately got dismissed out our door because Penn State wasn't covered. Not that I'm not suggesting that that's a reason to do it. I think it's unfair for Penn State to bear the mantle that if there would have been a strong right-to-know law, this could have been solved. I don't think that. There may have been things that have been done differently along the way to get it lots earlier, but for anybody that's thinking that a rewritten right-to-know law is going to prevent the next Jerry Sandusky, save your ink.
Thank you. Thank you, Mr. Chairman.